Good afternoon, everyone, and welcome. My name is Janine Najib. I'm president of the Milwaukee Muslim Women's Coalition, and I'm really honored today to be emceeing a program for Our Peaceful Home, the Family Strengthening and Domestic Violence Project of the Milwaukee Muslim Women's Coalition. This particular program today, Family Law and Divorce in Wisconsin, is part of our Let's Talk About It series that we have been having for the past 2 years, addressing a variety of topics that affect our families and youth. So I encourage you all to check out our website and our Facebook page and view our past sessions. Our immediate past sessions were about foster care, which was a 2-part session, and also about challenges among our youth. Today's session, we are so honored to have 2 wonderful guests with us. And we have 2 family law attorneys who are going to be discussing the topic of family law and divorce in Wisconsin, because as many of you know, Our Peaceful Home deals with many clients, and unfortunately, sometimes these relationships end up in divorce. And I think we think actually that it's really important for the community to be more aware about the laws in Wisconsin. So first, I'd like to welcome the supervising attorney at Civitas Law Group, attorney Jessica Marquez Murphy. She's a graduate of Marquette University Law School, and attorney Jessica is passionate about helping domestic violence survivors. She's served as a senior attorney for Central Legal, and in 2016, she joined Civitas Law Group. She also represents children as a guardian ad litem in contested custody and placement matters. So welcome, Attorney Jessica.
Thank you, Janan. Thank you for asking us to be here today.
We also welcome Attorney Haley Bianchi, who is also a graduate of Marquette Law School. Attorney Bianchi specializes in family law, and she joined Civitas Law Group in June of 2018. She also leads the Civitas Law Student Internship Program, and more importantly, she's the proud new mother of a beautiful baby boy. So congratulations, Attorney Haley, and welcome.
Thank you, Janan.
First of all, why don't we start with you, Attorney Jessica? Just give us just a little bit, very briefly, about yourself, your law experience, and the mission of Civitas Law Group, which is one of very few nonprofit law firms in the Milwaukee area.
Yeah, so I knew when I was in law school that I wanted to do family law. I knew that a big law firm just wasn't for me. So I joined Central Legal right out of law school and created or helped develop the program that is now their domestic violence program funded by United Way. Prior to that, and in the beginning years, had interned at what is now the Sojourner Family Peace Center. So became very familiar with the dynamics of domestic violence and brought that to my practice. And then after 10 years, I decided it was time for a change and joined the newly formed Civitas. We just celebrated our 5 years of being open as a nonprofit. And Michelle Velasquez, who is another attorney helping with some immigration matters with our firm, was one of the attorneys that started this because we knew that the need was great. There is a very limited number of resources for legal needs in Milwaukee. So we thought, we have the experience, let's give it a shot. And here we are 5 years later.
That's wonderful. Wonderful. Attorney Haley, why don't you let us know why this particular practice?
So very similar to Jess, I knew all throughout law school, even before going to law school, that I wanted to practice family law and work with families and children. I got very lucky and met Jess my 3rd year of law school. And so I started with Civitas right after graduating. And because we're a nonprofit, I just was kind of thrown into it, which was the best way for me to learn. And I can't picture myself practicing any other type of law. I also do some restraining orders. So that's been something that I've really enjoyed doing, working with the petitioners and going to the courthouse and representing them in domestic abuse injunction hearings or harassment restraining orders. So, yeah.
That's wonderful. That's very admirable that both of you are in this line of business, really. I'd like to just remind our audience that as we go along, please submit your questions in the comments section. And this will be posted both to Facebook and our website. And our email and office number will also be shared in the comments section. So anytime you have a question, please post it there. And so our presentation today and discussion is about divorce, but of course, before you have a divorce, you need to have a marriage. And so let's just kind of talk very briefly about marriage before we get to divorce. What does it mean to be legally married in Wisconsin?
So here in Wisconsin, we don't have common law marriage like other states. So just because you live together for, let's say, over 7 years is frequently the time period, you are not considered legally married. Here in Wisconsin, you do need to have your marriage certificate and have your marriage registered. You have your ceremony, albeit it can be at the courthouse. It's small, but there's a witness. We don't recognize common law marriage here. So you do have to have a more formal process. We also, the courts struggle to recognize religious marriages. And I know that's something that we're going to get into in these questions. But we have a lot of families or couples that come to us that have just had a religious ceremony, but never got the certificate, never went to the clerk's office. And if that's done here, the courts struggle to recognize that. There is some case law that suggests, maybe based on a certain amount of evidence, that you could convince the court that it is a marriage, but it's very difficult. Religious marriages that take place overseas are a different story that can be legally recognized here. So it's confusing. If you're married here, it needs to be the formal process. If you're married in another country, the courts will consider cultural or religious marriages there.
So maybe let's just to kind of jump on that issue. Why is it important here to have a legal marriage? How does that affect any particular rights or, let's say, decisions as a spouse, property rights, etc.?
I can speak to that.
Yeah.
So in Wisconsin, there's property laws that says if you're married, any assets, income, or debt that you incur during your marriage is split 50-50. So often it is beneficial to have a legal marriage here in Wisconsin, because even if your spouse is the one earning income, buying property, owning businesses, that is still technically 50% yours, even if you had nothing to do with it, just sitting at home. Also, for kiddos, any children that are born during the marriage are considered legally the husband's child. So even if the parties have been separated for years, but they're still married legally, the court will consider any child that's born to be that husband's child. So that's very important for a lot of our clients to know, because often they may be separated from their husband, but then have another child, and they're surprised to learn that legally the court still sees that child as their husband's child.
Just to add, so we have two avenues, basically. If you are married, and let's say it legally married, use that term, you go through the divorce process. And that entitles you to home maintenance. Like Haley was saying, 50% of up to 50% of the property, maybe more, depending on the factors. If you are not legally married, The only issues that the court can decide on are custody, placement, and child support. And so it would not entitle you to rights to the home that you may share, to maintenance or alimony, to 401k or retirement plans. So there is a big difference. You are entitled to a lot more in a marriage, financially, especially.
So what you're saying is that if someone here two individuals living in the United States, living here in Wisconsin, decided to just do a religious, let's say Islamic marriage, a nikah, and then for whatever reason, eventually that didn't work out, they decide on a divorce, that's going to be problematic for who?
It's problematic for the parties, or in particular for the parent or religious spouse that is seeking any financial support from the other party. So if it's just a religious marriage and they have children together, but they've been together for 15 years, the woman comes to us, our client comes to us and says, I need financial support. He's been supporting me for 15 years, but we don't have that marriage that would let us go to court and ask for maintenance or spousal support. Oh, but I've contributed to the house. I help pay the bills, but the house is in his name. Then there's issues with, is she entitled to any of the house? So it really leaves people that choose to just do a religious marriage here, potentially leave themselves in a very bad financial spot. The division is not equal then. You aren't guaranteed a half or a share in whatever property you've gathered as a couple. I know that in the communities that we work with, and I think you'll speak to this too, a lot of the mosques have now said that they will not perform the religious marriage without a certificate because they understand the problems of separation after just the religious marriage. It really doesn't entitle both parties to what they would be entitled to in a formal marriage.
So one of the issues that we encounter here and we hear about often is where individuals say, well, we're Muslim and we have a religious marriage and we have what is, a mahed, like, there's a particular gift that's given, for example, to the bride, or an agreement, for example, that if there's a divorce, this will be paid. But is that enforceable here? So if there's a divorce, is that enforceable?
I think yes.
Oh, thanks. So I've had a few cases like this. I think it could be argued in court at trial to ask for it to be enforced. However, it's going to depend kind of on the judge that you're in front of. I don't know. Unfortunately, that's kind of one of the unique areas of family law, is every judge, every commissioner has their own kind of take on stuff. But for this issue in particular, what I found a lot of judges saying is this contract was made, like, this contract isn't enforceable. So I think it's still an argument that could be brought in trial. I believe there is some case law regarding it, but not Wisconsin case law. So unfortunately, my answer to you is not very straightforward. And that's kind of a lot of the answers in family law is there's, well, maybe, but I don't know. Jess, do you have anything else want to add to it?
No, Haley's right. It does depend on the judge that you're in front of. I have been in front of the judge with a prior coworker who had to write a brief as to why that document or that agreement should be enforced by the courts here. I have had other judges say that it is not, you're trying to treat it as a prenuptial agreement, but it doesn't meet the terms of a prenuptial agreement. And I've had other judges who say that it does, and they will use it more like a property division, right? So this person has this. So if it's jewelry or it's money, a lot of times we can tie it to payment of debt, or we can try to get creative. but the actual contract on its own, the courts struggle to enforce that. So if it's another family, so like let's say wife's family was going to pay husband if she's the one that filed for divorce, the courts may also say that's a claim that they need to either take to the mosque or to small claims. That's a contract between the families, not between the two parties here in front of me today.
Interesting. So, can in Wisconsin law, is it allowable for an individual to marry more than have more than one spouse?
No.
Okay. All right. So let's move on a little bit now to divorce. Can we talk a little bit about what a no-fault divorce is? Sometimes we've gotten clients where they'll kind of come in believing that this particular spouse acted very, very poorly, very badly, and maybe they should be kind of like punished by the judge for cheating, or for being an alcoholic or a drug addict, or or doing whatever. So what is a no-fault divorce, and what is the role of the judge in all of this?
So here, okay, in a lot of states, it's a fault divorce, right? So you need to be able to tell the court why you're divorcing the other party. There was an affair, there's abuse. Here in Wisconsin, you can petition for a divorce and give absolutely no reason other than that your marriage is irretrievably broken. Nothing's going to fix it. You do not need to say why, though. And I think a lot of the reason behind that, too, is that if a relationship has fallen apart, let's say for abuse, someone shouldn't have to prove that to leave an unsafe relationship. But it also means that one of the ways it was explained to me was by a judge when I first started practicing. Family court is both emotion and evidence. And so the lawyers that do well in it recognize that the emotion runs strong in these cases. They're angry, they're in crisis, they think there should be retribution, but the family court is a court of evidence, right? And it's not a court of punishment. So we look at what are the factors, we have them listed in the statute, how do we divide property, and they don't say why. It doesn't give us reasons, well, because he cheated, then he should be punished. That's not how the laws and statutes in family court work, and it can be really frustrating. So that's where having a good lawyer, having the judge's understanding of that emotional toll is really helpful. I would venture to say it's why we feel like social workers a lot as lawyers in family law, because you're dealing so much with emotion, but the law doesn't necessarily address those emotional needs. It'll divide your property for you, it'll divorce you, it'll give you custody and placement orders, but it doesn't talk about like the feelings and the anger that you have. And that's really hard for a lot of our clients. But it does not matter why you are getting divorced. That said, if there is abuse, if there are AODA issues, we take those into consideration when it comes to custody and placement. So they are addressed in that regard, but they aren't reasons to get more maintenance or more spousal support. The only exception to that is if a person had an affair and it was long, they spent money, they bought a home, they spent a lot of money on gifts. We have something called marital waste, and it's hard to prove. It's a tricky one to bring to court. But if someone took marital funds and spent them on significant amount on that other person, that is a reason to recoup those funds.
Very helpful. So what is the difference between divorce or filing for divorce and a legal separation, and how long does the process take? Because sometimes you get clients that are familiar with a religious divorce that can be done in one day, whereas they come into the court system and don't really realize the process. So can you differentiate between divorce and legal separation and the time involved in that.
Sure, I can take this one. So the main difference that I always tell my clients is with a legal separation, you cannot remarry. So first, and also for religious purposes, some people choose a legal separation instead of a divorce. Otherwise, both will address property division, both will address custody and placement. So that's the main difference would be you can't remarry if you get a legal separation instead of a divorce. Now, if you choose to go with a legal separation, it's pretty easy then to come back later and ask for an actual divorce. How long does the process take? Both of them would take about the same amount of time. In Wisconsin, when you file for divorce, there's called a statutory waiting period. So once the opposing party, your spouse, is served the divorce or legal separation papers, you have to wait at least 120 days until a court could grant you your divorce or legal separation. And they call that the cooling off period. So some folks, they file for divorce and then they'll reconcile. So this is, I think the legislature was trying to avoid people getting married, divorce, and then remarrying again right away and wasting kind of court resources and time. So in Milwaukee County, though, it's very rare to get your divorce, unfortunately, in 120 days. It's going to take longer than 120 days. Even if you have agreements right away, just the court's calendar right now is really backed up because of COVID. So I always warn clients, even if you think you and your partner have all the agreements in the world, just be prepared that it might take like 6 months, closer to 6 months than that 120 days. If there's contested issues, so that means if you have disagreements regarding who's going to get the house or especially issues regarding the kiddos, then your divorce, it's hard to say, or your legal separation, it's hard to say when it can be concluded. I have some cases, unfortunately, that are like 2-year divorces because the parties, unfortunately, can't come to an agreement, and the courts keep scheduling out. Now, at the end of the day, if the parties cannot reach an agreement, the court can set it for trial, and that's when the judge would make the decision and then grant the final divorce or legal separation at that hearing.
Okay, great. So we have, well, let me ask this question first. How does getting a divorce affect or impact immigration or refugee status? Because we have seen cases where individuals have been married sometimes 5-6 years, and they thought that, that their spouse had applied for their immigration, green card, etc. And then they find out that they don't have any status. They don't have, a lot of things have not been done for them.
So this one, I would say.
You are muted, Jessica. Yeah.
Sorry. This one, I would say we would need to go to an immigration attorney for, because each of these cases is so fact specific about when you applied, did you come together, what was put in the affidavit. So this one, I don't know that it has a general answer because each client is going to have their own affidavit with their own set of facts that we would need to sit and talk with an immigration attorney. And we have Michelle. So if we have any clients watching or any clients that need that help, we can certainly set up a time to connect with Michelle and get those answers. But that one doesn't really carry a general answer, at least not to my knowledge. It's very fact specific.
Yeah. And I think the advice that I would give people that are listening is always making sure that you have your email address, your mailing, contact information with immigration up to date. And no, this is hard. It's always like hindsight is 2020, but never just relying on your spouse to do these things, following up on your own. And I know that's like I said, it's probably like, oh, well, I trusted him. But in these situations, really being an advocate for yourself and following up on your own and making sure that these things are being taken care of on your own is always kind of the best way to prevent this happening.
And keeping copies of all the documents.
Yes.
A lot of times we hear other clients saying the other party has all of my immigration paperwork, copies of everything.
So can one spouse divorce the other without their knowledge?
So sort of. The general procedure is everybody knows what's going on. Some people just choose not to participate. So we have filed the divorce, and then the paperwork needs to go out for service with the sheriff or a private process server. And that means that the paperwork that was filed, the case number, and any court dates given to the process server, and they go out and look for the spouse to actually personally hand them the paperwork. Or we have what's called substitute service, where you're giving the paperwork to someone who's over a certain age and is substantially related or has knowledge of this person. So like, let's say a son or a mom answers the door and says, yes, I can accept on his behalf. I will give it to him. The process server will note, I gave it to this person and this is the relation to this person. Substitute service works if they've tried a certain number of times before on straight personal service. If we don't have personal service or substitute service, we have to do what's called publication, where we provide to the court that we attempted personal service, we were unsuccessful. We don't have any other known addresses, and we have to send it to, here in Milwaukee, it's called the Daily Reporter. And they run in their legal section the summons and petition, and that's considered notice by the court. The issue with publication is we know that a lot of people aren't just picking up the Daily Reporter and reading it. So yes, I suppose someone could go through a divorce process, show that they've tried serving the party, were unsuccessful, printed it in the newspaper, and went through with the process. The courts have said, though, in publication cases, because they know that the other party might not even know that this is going on, they will not make orders regarding certain property issues because they don't have the right jurisdiction to do that. If I will get fancy, I think it's called in rem jurisdiction, but that takes me back to my law school days. And so they won't divide property. So if you have a publication case, you can be divorced. You can have custody and placement orders if you have children, child support orders, but we won't necessarily be able to divide houses, 401ks, and other things like that.
Yeah. And I know when I first heard of this, I was like, wait, so what if, like, if you're worried about your spouse going and filing for divorce and you never knowing, like, how, I know that seems silly, but how can you maybe check to see? And the best way to check is on CCAP. So say you separated from your spouse and you're concerned that they went and filed for divorce or legal separation. There's a website called the Wisconsin Circuit Court Access. What's the P stand for?
Program.
There we go. And you can search your full name or your spouse's name, and the case number would show up because divorces and legal separations are public record. So if you have concern that your spouse has filed, that's the best way to check and see if they have.
So what if, and we've had some cases like this, what if a spouse takes their spouse and leaves them in a foreign country that they had originally maybe gotten married in and takes their paperwork or maybe didn't apply for their paperwork and divorces them here and they are unaware of that? What options do they have?
Do you mean, maybe I just didn't understand the question. Do you mean they are here in the United States or they're in a different country?
Yeah, the spouse was left in a different country. And and usually in the cases we've had, the husband lives here in the United States and files maybe for divorce here. And the idea is to get away from paying alimony, to get away from dividing property. And so, the other person is obviously not present. So what is that situation like?
So there's a couple things. The court should be looking to see that the person has been to the state of Wisconsin and meets the requirements for the state of Wisconsin to have the divorce in the first place. So if someone's never lived in Wisconsin, doesn't have significant contacts in Wisconsin, like families here, hasn't stayed for even an
No,
extended
they lived here in Wisconsin, but then when in the time of wanting to get a divorce, they send the spouse overseas so that they because as you mentioned yourself, Wisconsin divorce laws gives pretty much 50-50. Whereas you dump your spouse overseas and come back here, you probably aren't giving them anything. So does that spouse that is overseas have any options? And what I can say, what I can mention right here actually is that we will be at the end of this month, we will be doing a presentation with also some lawyers from End Abuse, Wisconsin on transnational marriage abandonment. And so this is a unique thing. So I was just curious if you guys had encountered that sort of thing yet. Yeah.
No, I have not run into that. It could largely be because our caseload is generally our clients, right? The domestic
Right.
violence victims or survivors, not the other party who's trying to run from the spouse. So
Right.
I have actually not run into that. Obviously it happens. But I would be interested in how that works because what would be the solution if I suppose they could always come back and reopen the divorce action. There's a statute that allows for that because it was done under fraud or duress. They could prove that they were abandoned there. But yeah, no, that I'd definitely be interested in the answer to that.
Yeah, so maybe we will include the information for that in the chat as well. Is it possible? Can a spouse refuse a divorce? Refuse to sign divorce papers?
So a spouse can decide to not sign the divorce papers, but here in Wisconsin, all that matters is that the petitioner does what he or she needs to do to get the divorce pulled through. So what that means is you can't, I guess a lot of respondents can drag things out for petitioners, unfortunately, but at the end of the day, it doesn't matter if they don't want the divorce or if they are saying, no, I do not agree to the divorce. The court will still grant the divorce for the petitioner. The only thing that's important is that the petitioner will have had to serve the respondent. So we sometimes see where the respondent will evade service because they do not want to be served the divorce papers because they do not want the divorce. That gets tricky. Then we'll try serve them at their work. We'll try the substitute service. Maybe go the publication route if that, but then again, like Jess said, then you can't get those orders regarding property. So they can try to evade service, which can drag things out. But if you have service and the petitioner is filing the paperwork that he or she needs to file, the court will grant the divorce regardless of the respondent's cooperation or adamant disapproval of the divorce.
Okay. There are instances where sometimes the spouse, when they're in the process of a divorce, will try to hide assets. They will put assets in the name of other family members, for example, in order to hide it, or do other, other things in order to hide assets, even go as far as, not having, not being paid in a way that shows that they are being paid, which is all, from my opinion, kind of fraudulent kind of practices. But what is, maybe here is where you can kind of talk a little bit about that. If it's known that the abusive spouse is hiding assets. So what is discovery? What options do wives have in this situation?
So we run into that a lot. And the family court isn't, like I was saying earlier, the court of evidence. And so what does the evidence show? If there's a house and that house is in other family members' names, there's not a lot that the family court can do. Even if our client knows this is the house we live in, this is the house that he bought it with our money, but it's entirely in other parties' names. That doesn't mean that there isn't a court action in large claims, small claims, or somewhere else, but the family court would struggle with how to divide something that is not at all titled or held in one of the parties' names. In regards to a lot of our clients, my husband is self-employed and he's not accurately reporting his income, or he's paid in cash. It's the same thing. What evidence do we have of how much he's making? So sometimes we bring in Facebook posts where they're saying, I have a roofing company, or I'm running this business, even though they're not claiming it on their taxes. And so we try to prove that they have a higher income than they're actually reporting. But it is very difficult when someone is paid in cash to prove that. So then formal discovery comes in, and that's asking for bank statements to see if there are large deposits, more consistent large deposits. Are those coming from a job? Asking the person to answer interrogatories, which are questions essentially sworn under oath, just testimony taken outside of a courtroom, where they can have to answer questions about their bank accounts, about their jobs, and you use that in court to call into question their credibility. But it is really difficult because the court wants to see actual documentation of what they're paid or what exists in their name. And that's hard here.
Okay. Is an attorney needed to file for a divorce, or can individuals file divorce by themselves? And what's the average? Just curious, what's the average cost? I would imagine that if it's a divorce that's not contested, or like a no-fault divorce, it probably would be easier than if there's going to be, of course, a lot of discussion and argument about property, etc.
Yeah, so you don't have to have an attorney to file for divorce. You'd be considered pro se, which is a fancy way of saying you don't have an attorney. And there's actually some really great resources at the courthouse. They've been doing everything virtually now, but Milwaukee Justice Center, they help individuals fill out the divorce pleadings. And they have like really good, thorough instructions on what rooms to go to file things. They have instructions on how to bring the paperwork to the sheriff for service. It's a really great option for people, especially if they want to get the paperwork filed as soon as possible. Then they can do so on their own. For filing fees, you with minor children, I know it's $218. Without minor children, I think it's $198. And however, a lot of our clients will qualify for the fee waiver. So if you receive food share, W-2, or childcare, you can petition to the court to waive your fees. And that would include also the service fee for the sheriff, which I believe now the sheriff charges $90, I think, to serve. But with the fee waiver, you wouldn't have to pay for that service fee either. Now, for attorneys, for Janan, you were saying, does it cost different if there's no issues or if there are? With the court, it's the same fee. They don't care how many issues you have. It's $218 or $198. For the attorneys, it will depend on their office if they are charged hourly or if they do flat fees.
Okay, that's really helpful. Let's talk briefly about, abusive marriages, and that's generally with our peaceful home when people are kind of at wit's end and finally decide, to pursue divorce. It's usually after many years of abuse. So if we can talk just briefly about, so legally, what is, constitutes legally the definition of domestic violence, and also what is mandatory arrest as it pertains to DV. And as we know, for those of us that work in this field, that, domestic abuse in marriage is not just being black and blue and being beat up physically. There's, you can be locked in a room and not let out, and that's abuse, and not have a mark on you. There's emotional abuse, social isolation, financial abuse, verbal abuse. And so there's a lot of definitions to abuse, but maybe you can kind of give us a legal perspective.
So in the arena that we see the most, restraining orders in family court is a little bit different than the burden for criminal court. So for restraining orders in the civil division, its focus is very much on that physical abuse. Let me just read. I'll just read exactly. It says intentional infliction of physical pain or injury, intentional impairment of a physical condition, sexual assault, stalking, intentional damage to physical property belonging to the petitioner, or a threat to engage in the conduct of any of the above behaviors, the ones I just mentioned. So when you're filing for a restraining order, they really are looking for the physical abuse or threats of physical abuse, stalking, or sexual assault. And so, like you were just saying, we know domestic violence encompasses so much more than that. But for restraining order purposes, it is those things that I just listed. And so when we're filling out petitions with our clients, we really want them to focus in on the physical abuse or the threats of physical abuse. It is not okay to hit your wife. It is not okay to hit your children outside of the discipline that the Wisconsin statutes, and I have my own opinions on physical abuse, very strong opinions on disciplining children with corporal punishment, but it's not okay. And so when we file for restraining orders, we have the clients focus on hitting, pushing, slapping, shoving, getting in your face and spitting in your face, any of that physical contact that is threatening, threats of violence. I'm gonna, if you leave me, I'll hurt you, I'll kill myself, things like that. And then there's always the property damage. Property damage alone is a little bit tricky. If someone punches a hole in a wall, but doesn't threaten you when they're doing that, or come at you after that, sometimes I have been told during hearings, or by the police officers, it's a marital home, it's his property, he can damage it too. So you have to be able to show why that person felt threatened. So based on the history of the case, but we do know isolation. You can't go out with your friends. You need to stay here. You need to cook. You need to clean for me. You need to take care of the children. Don't have access to the bank accounts. I can't tell you how many of our clients don't know where their bank accounts are, who pays their car insurance, who has their car insurance, where their money comes from. They are so dependent on their spouse. And that can absolutely become a form of domestic abuse. And so I know that one of the things that matters for immigration purposes for the clients that we work with, especially, is that domestic violence needs to be disclosed on paperwork when you're coming over here. So if there are restraining orders, if there are criminal cases for domestic violence, that stuff all needs to be put on the applications. It matters. The Wisconsin courts have really tried to educate lawyers and judges, commissioners on the effects of domestic violence, especially the effects of domestic violence on children. But the criminal courts, that burden is higher. It is harder to get the police to refer a case over to the district attorney's office and have the district attorney prosecute. I don't know if you have anything you want to add, Haley.
No, I think you covered it really good.
Yeah. We have so many questions, honestly. Let me jump. I had quite a number of other questions regarding this, but let me get to briefly, and we can hopefully maybe have another session on this, if it's okay with you guys. Just children and divorce. I think that's the most heart-wrenching aspect of domestic abuse and divorce, because we have seen really where when there's abuse in the home, the emotional and the trauma and the long-term effects, even mental illness that sometimes comes as a result of living in homes where there's constant tension, even if it's not directed at children. And something that I know our Peaceful Home often educates about are what they call the damaging effects of ACEs, or adverse childhood experiences, that come as a result. And parents don't realize that the toxicity of those of what's going on in the marriage and how it affects long-term those children and their chances for having happy marriages, or even success, and not being affected by trauma. So the question that I have for both of you is that, so what happens to the children when a couple divorces? How is child custody and placement decided? And maybe what's the difference between child placement and child custody? And maybe I can also address the fact that sometimes, moms, because they don't want to get the husbands in trouble or whatever, they will cover even abuse of children, and not bring this up. And so what happens then with the children in that situation?
So there's a lot there. So I'll start. I think so. The way the family court, especially in Milwaukee County, they want the parents to come up with an agreement together about what's going to happen with their kids. And so in Wisconsin, there's custody and placement. Custody is the legal decision-making power. So this is where your kid goes to school. Does your child take medication? Does he or she get vaccinated? Those are custodial decisions. Placement is where the kiddo physically is. Who does she live with? Who does he stay with on the weekends? So they split those up in two. The court really wants parents to decide together. However, we know that that's not always possible. And especially if there's abuse and domestic violence, there's the power imbalance. And that's really not going to be in the child's best interest for the parties to make an agreement together. So sometimes the court will appoint a guardian ad litem. And Jess she does a lot of guardian ad litem work. I just started recently doing guardian ad litem work. And this is an attorney that represents the child's best interests. So this is not an attorney that represents your child or what your child wants, but it's an attorney that represents a big idea of what's in the child's best interest. And there's lots of factors that a guardian ad litem has to consider when they're determining or investigating what is in the child's best interest. So in these scenarios where there isn't an agreement regarding the kids, a guardian ad litem will get on board, and they will present their investigation and their recommendation to the court. And I'll let Jess kind of take over from that.
So there's 16 factors in custody and placement. And some of the most important factors that we take into consideration is whether or not domestic violence is present. Do we have any court convictions? Do we have any restraining orders? We are constantly being required to be educated on the effects of domestic violence on children, and helping the people that we're working with to understand that even if they're sleeping, even if their doors are closed when you're fighting or you think that they can't hear you, kids know. They can tell that they're very intuitive. They understand the dynamic between parents in a violent home. There's research done on their cortisol levels and how it affects their brain development. It truly impacts children. And it's why we see this cycle continuing, right? Domestic violence, for the most part, is a learned behavior. So the kids in the home, the boys are learning how to speak to the women in their lives. The girls in the home are learning what to expect from a relationship. Oh, this is how I'm supposed to be treated. This is normal. And it's how the cycle then perpetuates itself. And so in family court, guardian ad litems should take it very seriously. And when they're making recommendations about custody and placement, the law tells us where there is domestic violence present, there's been a finding of domestic violence, that we should go against the presumption of joint custody and award one parent or recommend that one parent, the non-abusing parent, receive sole custody, meaning that they could make the decisions themselves. And the reason for that is because how do you communicate with someone that is abusive? You should not be forced to make decisions with someone that is abusive. That presumption can be overcome by the batterer taking a batterer's treatment course. But we know that batterer's treatment courses have a low success rate. It's a learned behavior. It has to be unlearned, and that is very difficult. In regards to placement, when we're making recommendations and there's domestic violence present, we ask for supervised placement. So at agencies where they can see them in a supervised setting. The issue is that domestic violence isn't that end all be all to placement. And a lot of these batterers get placement either because they are incredibly manipulative. They're charmers. They come into court. They present well. They're educated. They, working at it. And they use all the tools in the book. And they end up with placement, or they say they've done the work. They're getting better. They're getting treatment. But we do the best we can with the statutes that we have and the resources we have in Milwaukee to try to keep the kids safe and to educate the parents about the effects of domestic violence on children. But I mean, people write books on it, years of programming. It's such a huge topic to unpack.
So let me ask you this. We have had instances where, sometimes survivors or the women have been pressured in the community to not go through the court system and to go through, for example, community members or individuals and just sign a document that will give up certain of their rights, and they are being promised that they will, make sure that they will get certain custody of kids or a certain amount of maintenance. And, we also know that it has not been, how can I say, practical in the sense that if the individual chooses then not to pay anything, there's nobody to enforce that. But I'm just curious as to your thoughts on these private contracts, about the idea of keeping this within the family, keeping it within, a private community, not going to the courts to get your rights. Yet you don't have the community individuals willing to sign and take responsibility to guarantee those rights if the spouse does not come through and put through those rights.
I think Jess and I would both agree that we would tell everyone that is a bad idea. Do not do that. You need to go to court, even though that may be very difficult, especially from like a lot of our clients, the communities that they're coming from. I know that there will be a lot of judgment, but it's not enforceable. Those agreements that are made outside of court, the court cannot enforce. And unfortunately, like we've seen some really sad situations where there's an agreement that they made just within the family or through their community, and one of the parties does not follow the agreement at all, and it's with the kids, and they take the kids, and the other party's calling the police, and the police are like, I can't do anything with this. This is not enforceable. And then you have to file for an action in court, and you're not going to wait months to get into court. And so I'd say, no, don't do that. Go to our peaceful home, talk with somebody, and then get some help with either an attorney or someone to help you, so you're not in that situation where you're out of luck.
The same goes for child support. We have a lot of clients that want to make agreements. So they've gone to court, they're in court, but they're saying he's agreeing, he's just going to pay me $400. We're not going to go through the child support system. That will never be the advice of Haley and I. When the agreements fall apart, as soon as you leave court, it's not enforceable. It's very difficult to come back right away to court to change your child support. If you've agreed to what's called a hold open, where the other spouse is not paying any child support, it should go through the system. The court needs to keep a record of it, because figure when a relationship breaks down, especially in the communities that we're working in, the people generally aren't collaborative. Our clients aren't in a place where these parties are talking and sharing a free flow of information and financial information. So when nobody's watching, they aren't going to pay. They're not going to, that abusive relationship just continues. So when we pay through the systems, through the court system, when we have agreements, we can at least try to go back and have those enforced. Or if we need to call the police have a specific custody and placement order that they can look at and say, you're supposed to get Friday, Saturday, and Sunday from 9 to 9. But without those things, there's not a lot that anyone, lawyers, courts can do for you if you choose not to go to court and make sort of a private agreement.
I just want to remind the audience, if you have any questions, we have a couple of questions that came in. I hope you guys don't mind just staying a few minutes over. But if you have any questions, please do include those in the chat. I also want to remind everyone that the goal of our peaceful home is really to strengthen families and reconciliation, but reconciliation that is peaceful, reconciliation that really gives dignity to each member of the family. We will never say yes to abuse in order to keep a family together. That does not work. That is not acceptable Islamically. It is not acceptable according to the law. It's not acceptable according to human rights in general. Every human being deserves dignity. They deserve to feel safe and stable. Every child should be in a stable and safe household, and we really work hard to see that happens. We can refer people to counseling services, to anger management services, to a lot of different things in order to try to work on those issues. but we will never, and I repeat, we will never endorse an abusive family. And so when that happens, that is when we jump in to make sure that that a person's rights are guaranteed. It's our responsibility. We believe as a Muslim women's organization, it is our responsibility. Let me ask. This question came in: is my husband doesn't pay child support that was ordered by the court, and he. So what options do I have?
So we would file what's called a contempt action, where we say to the court, this person was ordered to pay child support and he's not paying it. We need sanctions. Those sanctions could include jail time. They could include fines. They could include an increase in child support. So we would go back to court on what's called a contempt action. It's important to note that this is why we need to be in court in the first place, because if someone stopped paying child support and you don't have an order, then we have nothing to go to court with. I would ask my client to gather as much information as possible about where the person works. A lot of people leave their jobs and then don't update child support with where they're working. So any safe investigative work they can do, whether it's talking to friends, looking on Facebook, to gather information about where they think their spouse is working. We would ask them to do that, and we would go back to court and ask for sanctions against that person.
Great. Let's see. Yeah, I think we answered the other question here. So before we end, I just once again would like everyone to know that our Peaceful Home here at the Milwaukee Muslim Women's Coalition is a culturally specific resource for our community. We understand our culture, we understand our faith, we understand the trauma of people coming from, whether it's refugee settings or certain, places and some of the cultural practices that are actually not acceptable Islamically, but unfortunately have found their way. And so we work to help people through all of this. We are bound by confidentiality. We have multilingual advocates in many different languages. We're able to help with everything from restraining orders to helping to get housing, transitional housing, and to get to work with some of these awesome legal representatives and lawyers as well. Our doors and our phone lines are always open. I just want to thank Attorney Jessica Marquez Murphy and Attorney Haley Bianchi for joining us this afternoon. I know how busy both of you are. And along with all of the attorneys at Civitas that have been incredibly helpful to us. Thank you so much for working so closely with our advocates and our clients. And we'd like to thank all of you for watching, and we hope that you will share this with others. And I think the message today is there's no excuse to not be informed yourself, to not advocate for yourself. To not be aware of all aspects of your marriage. We wish everyone happy families and happy marriages, but ignorance is never an option. So thank you all for watching and have a great day. And thank you to both of you.
Thank you, Janan, and thank you for everything that you guys do at the Milwaukee Women's. Phenomenal work. Thank you.
Yes, thank you.